I watched the Fifth Circuit Court of Appeals issue a ruling that struck down multiple concealed carry restrictions in a single opinion. Not one restriction, not two. An entire framework of limitations that states had been using to control where and how citizens could carry firearms in public. The decision received almost no national media coverage, but it just invalidated similar restrictions in dozens of states across the country. The case involved Texas, Louisiana, and Mississippi, the three states within the Fifth Circuit's jurisdiction. But the constitutional reasoning applies nationwide. And within 48 hours of the decision being published, attorneys general in 17 different states received legal memos warning that their concealed carry laws are now presumptively unconstitutional under the same analysis. The restrictions that fell were not fringe regulations. These were mainstream limitations that exist in nearly every state. Prohibitions on carrying in bars and restaurants that serve alcohol, prohibitions on carrying in places of worship, prohibitions on carrying in public parks, prohibitions on carrying at private businesses that post no-gun signs, prohibitions on carrying at political demonstrations or protests. The Fifth Circuit held that none of these restrictions have sufficient historical foundation to survive constitutional scrutiny. That conclusion was not based on policy disagreement. It was based on applying the framework the Supreme Court established in Bruen. States must prove that modern restrictions are consistent with historical tradition. The Fifth Circuit examined the historical record from the founding era and Reconstruction period, and it found no evidence that the founding generation prohibited concealed carry in these categories of locations. There were colonial-era restrictions on carrying in specific sensitive places, courthouses, legislative chambers, polling places during elections. But those restrictions were narrow and specific. They did not extend to entire categories of private property based on what activities occurred there. They did not prohibit carry in all places where alcohol was served. They did not prohibit carry in all places of worship. They did not give property owners authority to criminalize carry through posted signs. The Fifth Circuit concluded that modern restrictions go far beyond what historical tradition supports, and when modern restrictions lack historical foundation, they are unconstitutional regardless of how reasonable or well-intentioned they might be. The implications are immediate. Texas, Louisiana, and Mississippi must stop enforcing these restrictions. Citizens in those states can now legally carry concealed firearms in locations that were previously prohibited. Property owners can still ask people to leave, but they cannot use criminal law to enforce no-guns policies. The distinction matters because criminal enforcement carries penalties including arrest, prosecution, fines, and potential imprisonment. But the larger impact extends beyond the Fifth Circuit, because other circuits face the same constitutional question. And when one circuit invalidates restrictions based on lack of historical evidence, other circuits struggle to reach different conclusions using the same analytical framework. The historical record is the same everywhere. If Texas's restrictions lack historical foundation, then California's restrictions lack historical foundation. If Louisiana's prohibitions are unconstitutional, then New York's prohibitions are unconstitutional. Multiple states are already responding. Some are preparing appeals to the Supreme Court, hoping for clarification or reversal. Others are drafting new legislation designed to comply with the historical tradition test while preserving some limits on public carry. A few states are simply waiting to see whether federal courts in their jurisdictions issue similar rulings before taking action. But waiting may not be an option, because the Fifth Circuit decision creates immediate legal vulnerability for states with similar restrictions. Any citizen charged with violating a carry prohibition can now cite this decision as binding precedent that the restriction is unconstitutional. Prosecutors in states outside the Fifth Circuit might continue bringing charges, but defense attorneys will argue that the Fifth Circuit got the constitutional analysis correct. And judges who apply the same historical framework will likely reach the same conclusion. The decision addressed several specific categories of restrictions that exist in multiple states. Each category presents its own constitutional problems under the historical tradition test. Alcohol-serving establishments were among the first restrictions to fall. Many states prohibit concealed carry in any location that serves alcohol, or in locations where alcohol sales exceed a certain percentage of total revenue. The Fifth Circuit found no historical tradition supporting these blanket prohibitions. The founding generation had taverns, inns, and public houses where alcohol was served. There is no evidence of laws prohibiting armed citizens from entering these establishments. Some jurisdictions prohibited intoxicated persons from carrying weapons, but prohibiting sober, law-abiding citizens from carrying in locations where others might be drinking has no historical analog. Places of worship present a more complex question, but the Fifth Circuit reached the same conclusion. Many states prohibit concealed carry in churches, synagogues, mosques, and other religious buildings. The stated justification is that these are sensitive places where weapons are particularly inappropriate. But the historical evidence does not support treating all religious buildings as sensitive locations. While some colonial-era communities may have had informal customs against carrying in church, there were no widespread legal prohibitions, and custom is not the same as legal mandate. If the founding generation did not legally prohibit carry in churches, modern states cannot claim historical tradition as justification. Public parks faced similar analysis. Multiple states prohibit concealed carry in city parks, state parks, and recreational areas. The argument is that these are family-friendly spaces where firearms are inappropriate. But parks and public recreational areas existed in the founding era. There is no evidence of laws prohibiting armed citizens from these spaces. The Fifth Circuit noted that prohibiting carry in parks actually contradicts historical tradition, because hunting and outdoor recreation were common lawful purposes for carrying firearms. Private property with posted signs created the most significant shift. Many states give property owners authority to prohibit concealed carry by posting signs and make violation of those signs a criminal offense. This converts private preference into criminal law. The Fifth Circuit held that this lacks historical foundation. Property owners have always had authority to set rules for their property and to ask people to leave. But the founding generation did not criminalize the mere presence of a firearm on private property against the owner's wishes. Trespass, after being asked to leave, was the remedy, not criminal weapons charges for initial entry while armed. The decision does not eliminate all carry restrictions. The Fifth Circuit acknowledged that certain locations can be prohibited based on clear historical tradition. Courthouses, legislative chambers, polling places on Election Day, schools and university campuses have stronger historical arguments, though even those are being challenged in other pending cases. But the list of historically supported sensitive places is much shorter than the list of locations states have been prohibiting. This creates practical problems for states trying to maintain public safety restrictions while complying with constitutional requirements. If most location-based prohibitions lack historical foundation, states have few tools remaining to limit where firearms can be carried. Some states are exploring alternative approaches, requiring additional training for carry in certain locations, creating liability rules that don't involve criminal penalties, strengthening property rights to exclude armed individuals through civil rather than criminal mechanisms. But each alternative faces its own constitutional questions. If the core right is to carry firearms for self-defense, can states burden that right with extensive training requirements? If property owners can exclude armed individuals through civil process, does that achieve the same practical result as criminal prohibition? These questions are being litigated now in multiple jurisdictions. The Fifth Circuit decision also addressed permit requirements and application processes. Many states require applicants to demonstrate good cause or specific need for a carry permit. Others require letters of recommendation from community members. Some require discretionary interviews with law enforcement. The Fifth Circuit found that these requirements impose unconstitutional burdens on Second Amendment rights. The historical analysis is straightforward. The founding generation did not require citizens to justify their need for arms before exercising the right to bear them. Carry was generally unrestricted for law-abiding citizens. Some jurisdictions required oaths of loyalty during wartime. Some prohibited dangerous individuals based on prior conduct, but requiring average citizens to demonstrate special need before exercising a constitutional right has no historical precedent. This portion of the decision affects shall-issue states as well as may-issue states. Even states that must issue permits to qualified applicants often impose requirements that lack historical foundation. Expensive fees, long waiting periods, extensive training mandates, fingerprinting and photographing. These requirements may seem reasonable as policy matters, but if they have no roots in historical tradition, they cannot survive constitutional scrutiny under the framework the Supreme Court established. The timing of this decision matters. The Fifth Circuit is one of the most influential courts in the country. Its rulings are frequently cited by other circuits, and on Second Amendment issues, the Fifth Circuit has been consistently applying the Bruen framework strictly and faithfully. When the circuit speaks on gun rights, other courts listen. The decision is also emerging as states are still adjusting to the Bruen framework. Many legislatures passed new carry restrictions after Bruen, attempting to craft regulations that would satisfy historical tradition requirements. Those new laws are now being challenged, and early results suggest that most of them failed the test. States tried to be clever. They defined sensitive places broadly. They created buffer zones around prohibited locations. They imposed process requirements that made permits difficult to obtain. The Fifth Circuit just told them that cleverness does not overcome constitutional requirements. Federal courts and other circuits are now watching. Some judges will follow the Fifth Circuit's reasoning. Others will try to distinguish their state's restrictions based on minor differences in statutory language or local history. But the core constitutional analysis is the same everywhere. If restrictions lack historical foundation in one state, they lack historical foundation in all states. The practical effect for citizens is significant. In the three Fifth Circuit states, carry restrictions have been dramatically reduced. Citizens who previously could not carry in churches, parks, or restaurants can now do so legally. Citizens who faced burdensome permit application requirements now have clearer paths to lawful carry, and citizens who were prosecuted for violating location-based prohibitions may have grounds to challenge their convictions. But uncertainty remains. States are still enforcing some restrictions while they assess which ones might survive legal challenge. Local jurisdictions are interpreting the decision differently. Some prosecutors are dismissing pending charges. Others are continuing to prosecute while waiting for appeals. Citizens face the difficult question of whether to exercise newly recognized rights, knowing that state officials might still attempt enforcement. The Fifth Circuit tried to provide clarity, but clarity in constitutional law often takes years to fully develop. Multiple cases must work through courts. Conflicts must be resolved. Boundaries must be defined. The process has started. The direction is clear. Carry restrictions without historical foundation are falling. States that continue enforcing them face inevitable invalidation. I have watched constitutional doctrine reshape legal reality before, not in the Second Amendment context specifically, but in other areas where the Supreme Court established a new framework and lower courts began applying it faithfully. The change does not happen instantly, but it happens steadily. Case by case, circuit by circuit, restriction by restriction, the law adjusts to match constitutional requirements. That adjustment is happening now. The Fifth Circuit just accelerated the process. Concealed carry restrictions that states assumed were obviously constitutional are being struck down based on historical analysis. The restrictions had no historical foundation. They were 20th century policy inventions. And 20th century policy inventions cannot override constitutional rights rooted in 18th century tradition. The Second Amendment, as currently interpreted by federal courts, protects the right to carry firearms in public for self-defense. That right includes carrying in most public places and most private property open to the public. States can prohibit carry in a narrow category of genuinely sensitive locations with clear historical precedent. Everything else requires historical justification. And for most modern restrictions, that justification does not exist. Dozens of states are now examining their concealed carry laws, knowing that many provisions cannot survive the analysis the Fifth Circuit just applied. Some will repeal restrictions proactively. Others will wait for lawsuits. But the endpoint is predictable. Carry restrictions are collapsing under historical scrutiny. And the Fifth Circuit just provided the roadmap every other court will follow.